Hi everyone, Rod Armande, immigration and personal injury attorney. So you've met somebody and you've fallen in love and you happen to be a US citizen or that person is a US citizen. Basically one of you are not a US citizen and that person who's not a US citizen lives abroad. So now you want to somehow, of course, live here in the United States together. And what can you do? Well, you have two options. I mean, we've all seen the reality show 90 Day Fiance. That's actually one of the options. And the other one is a spousal immigrant visa. And so, what are the difference? Basically, the main differences for they both have two steps. You basically have to file a petition. That petition has to get approved. Currently, in the last 2 years, they're taking about the same amount of time to get approved. Even sometimes the I-29F, which you have to file for a fiance visa, is being taking even longer than an I-130 traditionally, or many years ago it would happen a lot faster, and so that was an incentive to do a fiance visa to get your loved one into the country sooner. But basically the petition process for both the spousal, which is an I-130, and the fiance visa, which is the I-129F, take about the same amount of time to get approved. And then once you get it approved, you have to do a second step, which is basically you have to file some other forms and you have to schedule an interview and submit some other documents, do a medical exam, and then schedule an interview at a U.S. embassy abroad. Depending on what country you're living in or what country you're able to travel to have that interview will dictate how fast you can get the interview, basically. And so basically those two steps are the same for whether you're married or you are engaged and you intend to get married once you enter the United States. So let's quickly just talk about the fiance visa. The fiance visa, you basically have to have an intent to get married within 90 days of entering the country. So that standard of proof is much lower than a spousal marriage visa, where you have to show a bona fide marriage bona fide marriage, and you have to show bona fide marriage documents. So basically, for the K1 visa, they cannot deny based on the closeness of the relationship, because you just have to have an intent to get married within 90 days of entering the country. And if, it's like a trial period. If you happen to not get married within 90 days, you have a grace period to return to the United States, and that's fine. But if you do get married after you enter with the fiance visa, then you would file for a green card, a work permit. You're not able to work when you're on a fiance visa until you actually file for the green card. You get married, of course, first, and then you file for the green card and the work permit. But for the spousal, you will, even though the standard of proof is higher, when you enter the country, you will basically get a green card mailed to you, permanent residency card mailed to you within a few weeks, and you can use that to work and contribute to your household. And so that's the advantage of doing a spousal. But really, it kind of depends on your relationship and how long have you guys been in a relationship. Did you guys just meet? Or do have you been married maybe abroad, and maybe you have even children together, then or you're considering getting married and you have children together? Well, it's probably better you just get married, because the processing time is taking about the same. So it really depends on the relationship. And I always turn it over to the client to say, hey, these are the pros and cons. This is what's going on right now in the last couple of years. And you, depending on your relationship, can make a informed decision as to what to do next. Do you want to do the K1 visa route, or do you want to do the green card visa route? Besides that, of course, for the fiance visa, you do have to show that you've met each other in person in the last 2 years. So besides just showing an intent to get married, it can't just be like you met each other online and you haven't even seen each other in person. You have to actually have physically seen each other. There are a couple exceptions, but they're rarely ever granted. It's basically you have to show extreme hardship to the United States citizen fiance, or there are what they call violate strict and long established customs of the beneficiary's foreign culture or social practice. Beneficiary being the non-U.S. citizen who's being petitioned to come to the United States to unite with the U.S. citizen. Of course, for the spousal visa, also, you could be just a green card holder or permanent resident, and you could file for your spouse, so you don't need to be a U.S. citizen, unlike the K1 visa, the Fiancé Visa, where you do have to be a U.S. citizen to be able to file this petition. Besides that, I mean, there's of course, other requirements. The beneficiary shouldn't have any serious crimes. Even the petitioner shouldn't have any serious crimes that involve domestic violence or kidnapping, stuff like that. Those are all very specific requirements. So, of course, please consult with an attorney. If you're considering either of these applications, you can reach me at 213-567-4494. You can go to www.rodarmandelaw.com, or you can click the link on my bio and you can schedule a strategy session with me to discuss your case. I look forward to speaking to you, and have a nice day.